Once again, good evening, ladies and gentlemen, and welcome to the first Hyatt Fund event of the spring 2010 semester. My name is Tariq Downey, and I'll be moderating this event this evening. The Black Law Students Association is proud to host this most timely and relevant discussion on profiling, policy, and police conduct in a post-9/11 society. As I previously mentioned, this event was made possible by the Hyatt Student Activities Fund, which provides student organizations with funding to bring distinguished speakers to the law school and to support student-initiated activities that will enrich the law student body and spur intellectual development. The Black Law Students Association recognizes the importance of diversity education, and in hosting this panel, we hope to provide the Vanderbilt community with more knowledge and an increased understanding of these issues. Before we get started, there are a few ground rules. First, I will present the questions to our panelists. Any panelist may address any question. Once a panelist has addressed a question, we will take questions from the audience if that response has spurred a question from the audience. We will not address unrelated questions until the designated time, which will be at approximately 6:45. The time is now 6:09.
Synchronized watches.
Very military,
Yes.
Very military-like bearing there.
At that time, we will address all questions from the audience. Once again, if a response from our panelists spurs a question, feel free to raise your hand and approach. Do we have microphones? Well, there are microphones. There's one to your rear, my left, your right, and your left, my right. So it's on both sides. And raise your hand and approach the mic and address the panelists. I will now introduce our distinguished panelists. Starting from my left, we have our first panelist, which is David Singleton, who is the executive director of the Ohio Justice and Policy Center, a nonprofit organization seeking to reform Ohio's justice system. He received his J.D. cum laude from Harvard University, and he also teaches a seminar on constitutional issues in criminal justice at Northern Kentucky University College of Law. Our next panelist is Reginald Shuford. My apologies.
All right.
He's senior counsel at the American Civil Liberties Union, and he received his J.D. from the University of North Carolina. He now leads the ACLU, and he leads the racial profiling litigation efforts of the American Civil Liberties Union. He writes and speaks regularly on the issue of racial profiling and has appeared in numerous radio and television shows. Last, but certainly not least, we have our very own Professor Christopher Slobogin, who is the director of the criminal justice program here at the law school and was recently inducted as the Milton Underwood Professor of Law. Professor Slobogin received his J.D. and LLM from the University of Virginia. He's an expert in criminal procedure and mental health law and evidence law. He has authored or co-authored more than 70 articles, books, and chapters on the topics and is one of the 20 most cited criminal law and procedural law professors in the country. Please give a hand to the distinguished. Now I will ask each panelist to briefly state their reasons for agreeing to appear on the panel, and to speak freely on the aforementioned issues. You will have 5 minutes. We'll start with Mr. Singleton.
Well, thanks for having us here. I'm delighted to present and to talk about these issues. At the Ohio Justice and Policy Center, we focus on criminal justice reform. We represent folks who are incarcerated. We represent folks coming out of prison, trying to help them get on their feet and be productive members of the community. But we also do a lot of work on the front end of the criminal justice system. In addition to our school-to-prison pipeline work, we focus some of our resources on racial profiling issues. So I am here to talk about my experience in Ohio, but it's not just my experience as someone who litigates these cases and thinks about the broader policy issues. You know, I've been profiled myself several times, pre-9/11, post-9/11, and I have some very personal feelings about profiling based on that. I think it's legally, morally wrong to stop people solely based on their race. But in addition to those concerns, do we really make ourselves safer? And I think that we live in a society where we all want safety. We can all find common ground around that concern, whether we're black, white, Republican, Democrat, conservative, liberal, however we identify ourselves. We want safety. But often when we are most afraid, we do things that are counterproductive. And in my community of Cincinnati, and I'll talk a little bit more about this later, there is major distrust in the African American community of the police. And there are crimes that go unsolved in that community because folks feel like the police are not their friends, that they are always the targets, that they are stopped based solely on their race. And does that make us safer in Cincinnati? I don't think so. So I think we always have to keep in mind that while we might feel like we can accept certain police tactics because we all want to be safe and we're afraid, there's a question about whether that really does accomplish the safety that we're after. So that's what I wanted to say to start.
Thank
Awesome.
you.
Thank you very much for allowing me to be here as well this evening. So I think the question is essentially why are we here? And I'm here for a number of reasons. Number one, because notwithstanding proclamations of a post-racial society, the reality is that we are not in one. Racial discrimination and racial profiling continue to happen. I'm here on behalf of countless, nameless individuals who have been the victims of racial profiling, including many of my clients. I'm here on behalf of Sergeant Rosano Gerald and his 12-year-old son Gregory, 12 at the time, who were traveling for a family reunion from Maryland to Oklahoma, were stopped a very, very hot August Oklahoma day and racially profiled, detained for an hour and a half, allegedly for not signaling when changing lanes, which necessitated a second car, a K-9 car, coming up. Sergeant Gerald, who had spent the majority of his adult life in the Army at that point, was separated from his 12-year-old son, handcuffed. Gregory, the son, was placed in the second car with the dog. Gregory was in the front, the dog, a big German Shepherd, barking, growling, salivating on Gregory. And obviously nothing was found. I'm here on behalf of them and have learned two things in particular from that experience that I'll never forget. The first thing that Sergeant Gerald told me was, over the course of my representation of him, was to point out the irony of having spent years abroad, the majority of his adult life, representing American notions of democracy and fairness, et cetera, around the world, but to come back to his own country and be made to feel like a second-class citizen. So I'm here on his behalf and on behalf of his son, who, the second point, was that when Gregory, his only child, was a baby, he held him in his arms and said, "The one thing that I can always guarantee you is that I will always protect you." And when he was separated from Gregory and unable to see where Gregory was, he felt, though it wasn't his fault, that he had let his son down, that he had broken his promise to his only son. I'm here on behalf of Raed Jarrar, who in August 2006 was attempting to fly from JFK to LA back home, and was wearing, Raed Jarrar is an Iraqi-born resident now of the U.S., but clearly Arab in appearance, who was an activist, primarily something that didn't exist back in the day, but now is an internet activist, if you will, among other things, who was wearing a T-shirt that said, "We will not be silent," in both Arabic and English subscript. He was forbidden from boarding that JetBlue flight that day. He was told by a TSA officer that to wear such a shirt on a plane is akin to going to a bank and saying, "I'm a bank robber." Not only was he not allowed to fly with that shirt and made to wear another shirt, his seat was moved from the very front of the plane to the very back of the bathroom, and he was told that he needed to surrender his seat in order to accommodate a mother and child traveling together. We subsequently learned in discovery that that was not reality. I'm here on behalf of Latino men in Virginia, 4 who were congregated in their neighborhood and accused of loitering and trespass merely because they were standing around in their neighborhood. I'm here on behalf of Jordan Miles, an 18-year-old violinist who recently was beaten by 3 white undercover police officers in Pittsburgh who accused him of having a gun under his coat. In reality, if anything, it was a soda bottle, and that is not necessarily proven fact either. I'm here because racial profiling is proven over and over again to be ineffective, it doesn't work, it's counterproductive, it undermines law enforcement efficacy, it's immoral, it contravenes strongly, closely held notions of equality and fair play, and it's illegal. It violates the Constitution and other statutory provisions. I'm also here, I'm a Southern boy, so it would be remiss of me to not thank Tariq for having me. I'm here at his invitation and the invitation of Balsa and the law school, so I look forward to having this conversation with you.
All righty, thank you.
Thanks. Well, I'm honored to be on the same panel as David and Reggie. And I have to say I don't have the experience that they've had, either personally in terms of racial profiling or in terms of representing clients who have been affected by racial profiling. And so I'm going to actually approach this from a slightly different angle. I am very interested in racial profiling, and I have something to say about it. But for my introductory remarks, I want to talk about profiling more generally. But I do want to mention before I talk about profiling more generally that I have been profiled once, way back when I had a beard, long hair, and a backpack. I was stopped precisely for those reasons and for no other. And so that's a form of profiling as well. I wasn't routinely subjected to profiling. I did not have the kind of experience that I think a lot of people who are African American or Latino have in this country on a routine basis. But I have a little bit of a sense of what it's like. I want to describe that experience briefly. But what I mostly want to do in these introductory remarks is talk about profiling generally. And I think it's important to realize that police profile all the time. They don't always use race. In fact, quite often they use other kinds of criteria. One could argue that they are profiling any time they stop anyone for something short of a crime. In other words, any time they engage in preventive policing. Many of you know about the case of Terry versus Ohio, a very famous case back in 1967 decided by the Supreme Court. And many of you may remember the facts of that case. Officer McFadden, on his patrol, saw 2 different individuals walking in front of a storefront 24 times, and then occasionally confer with a 3rd person, and then go back and check out the storefront again. He ended up stopping those 3 individuals, frisking 2 of them, and the case eventually got to the United States Supreme Court, where the Supreme Court said it was permissible for Officer McFadden to stop and frisk these individuals. Now, what was the basis for Officer McFadden's action? It was a profile. He was concluding that anyone who walks in front of a storefront 24 times must be up to no good, must be thinking about burglarizing that place or doing something else that would involve wrongdoing. If he had retired at that point and gone to the academy to teach recruits, he might have taught them a class about what to look for when you're looking for burglars. And he might have mentioned this kind of activity. The recruits would have written those words down, and their notes would have essentially been a profile. This is a profile of an incipient burglar. And the point I'm trying to make is that conceptually there's not much of a difference between what Officer McFadden does and some of the racial profiling case did and what some of the racial profiling cases involve. Though in Terry, arguably race was not involved. Other criteria were. And there's arguably a problem with that kind of profiling as well as with racial profiling. I want to mention 3 other kinds of examples, which sound a little bit different than what happened in Terry versus Ohio, but nonetheless help make the point I'm making. Back in the 60s and 70s, we had a number of planes that were hijacked, believe it or not. I know we've been focused on hijacking recently, but it was relatively routine, unfortunately, back in the 60s and 70s. The federal government wanted to do something about it, so they came up with the hijacker profile. And the way they came up with this profile is they looked very closely at 30 known hijackers and determined what kinds of variables, what kinds of characteristics these 30 individuals had, and came up with a profile that represented what the normal, average hijacker looked like. They then applied it to over 750,000 airplane passengers. They identified 1,500 people who met the profile, and 4% of these, or about 40 people, were actually denied boarding based on the profile. So that's one kind of profile, a hijacker profile, not based on race. I happen to know because I know what the criteria are, though I'm not allowed to reveal them upon pain of death. But based on factors that are short of crime. None of these factors were crimes in and of themselves, and that's one possible definition of a profile. A set of characteristics, none of which are crime in and of themselves, but conceivably correlate with crime. Then another example, in the 70s and 80s, a number of federal and state police departments developed drug courier profiles, and you've probably all heard about this. These drug courier profiles were nowhere near as scientific as the hijacker profiles. I think it's safe to say. The hijacker profiles in and of themselves were not very scientific, but at least they made an attempt to be relatively reliable in the way they came up with the characteristics, and they did cross-validate it on another sample. Well, these drug courier profiles didn't come close to being the kind of profiles that the hijacker profiles were. So, for instance, as Justice Marshall pointed out in United States versus Sokolow, some of these profiles fixate, and these all, by the way, applied in airports, at least initially. Justice Marshall pointed out that some of these profiles listed as a key factor the fact that the individual was the first to get off the plane. Others listed as a key factor that he was the last person to get off the plane. Others that he got off in the middle of the crowd, and others that he got off a quarter of the way through. Well, immediately you suspect that there's something else going on here besides a scientific approach to profiling. Some emphasize no luggage. Some emphasize brand new suitcases. Some emphasize gym bags. You get the point. They were sort of made up as the police went along, basically an ex post rationalization for the kind of thing they did. These were all, however, denominated as profiles. So it's another kind of profile. Third kind of profile, and then I'm going to stop. But the third kind of profile I think it's worth talking about is something that's come along since 9/11. And part of our title has to do with 9/11. Something called total information awareness. It was the brainchild of Admiral Poindexter. You may remember him. It was designed to designate terrorists, but what it involved was accumulating information about all of us, literally billions of records, financial records, medical records, travel records, housing records, and even veterinarian records. And then once all this information was accumulated, a quote-unquote terrorist profile was to be applied to this information to see who deserves special attention. This program, TIA, Total Information Awareness, and the name in and of itself is scary enough, was defunded in 2003, but it still exists in various forms. One reason it was defunded is because it didn't catch too many terrorists. In addition, it also violated privacy in a major way. So the one point I want to make, and then we'll get on to the questions, is that I don't think there's any conceptual difference between what Officer McFadden did in Terry versus Ohio and these other kinds of profiles. In all of these situations, the police are relying on factors that are not in and of themselves crimes in order to try to prevent crime from occurring. One common characteristic of all these profiles is that they are not very good, and that's already been alluded to by David and Reggie, that police often make mistakes applying these profiles. So one thing I think we're going to talk about today is whether it's based on race or not, whether it's partially based on race or not, whether we should ever profile, whether it's ever permissible to engage in preventive policing, and if so, under what circumstances.
And that is a beautiful segue to the first question. Is there ever a time where profiling is acceptable, e.g. profiling behavior at the airport, as you alluded to earlier? And you can answer this in any order, gentlemen.
All right, I'll jump in. I don't have a problem with what Officer McFadden did. That seems to me to be very specific information that he had that that would make most of us, in a just applying common sense, think that something's about to happen. They're casing the joint. If there's not, if that is not casing the joint, what is, right? When I am walking down the street, I used to live in New York City. I lived up near Columbia University in a sort of a rough patch up there on Amsterdam Avenue. And the police are jumping out of their cars and asking every black man they see to stop, including me, and saying and starting actually to search me And I'm like, look, I just came off the train. I just came from this conference in D.C. What are you doing to me? I'm a lawyer. Leave me alone. Oh, I'm sorry. I didn't have a crystal ball. I could not see that. I don't know that information. That was what the officer told me. That's not right. And that much I know. And that was based, now maybe they would say that my presence in a high-crime neighborhood, being a black man and applying their common sense, knowing that crime happened in that community, and that often the crime that happened in that community involved brown and black folks, not exclusively. Maybe they would say that those combination of facts were reasonable to give them some basis to stop me. Well, legally, I don't think they would have had any ground to stand on. But that is not right. And I think the rub is trying to figure out the more difficult cases in the middle. Because I think we all would say that certain common sense ought to be applied, but it ought to not be driven mostly by somebody's race or stereotypes.
I have no problem with what Officer McFadden did either. I just wanted to point out that I think he was profiling just like the police you're talking about, profiling just like what happens at airports. The reason I have no problem with what Officer McFadden did is I think there's a very high correlation between what he saw and incipient crime, whereas there's a much lower correlation in the kind of situation you're talking about. And that, I think, is what we need to grapple with, is when we have a profile that's pretty good at what it does, and when we don't. The reason I started with Officer McFadden is, first of all, I think it may not have been immediately obvious that he was profiling, but secondly, of course, as you know, Terry versus Ohio ended up authorizing stops and frisks. And that's what happens to you in New York. Terry authorized at least
he's left New York.
Right now, it's on to you
sorry. You in New York.
To me now.
And so, as you all know, if you've taken criminal procedure, Terry versus Ohio allows a stop, which is short of an arrest, based on something called reasonable suspicion, which is short of the probable cause you need for arrest. Well, we still don't know what reasonable suspicion is exactly. It's not probable cause, which is what you need for arrest. It's not just a hunch. It has to be something that's articulable. But how much articulation do you need before you can stop someone? And even though I agree that Officer McFadden operated appropriately, there's some very interesting research that comes out of New York. You may know about this, which analyzed 175,000 pedestrian stops. In other words, 175,000 Officer McFadden stops based on reasonable suspicion. Only 2% of the people stopped during this 15-month period. These 175,000 people ended up being arrested. 2% out of 175,000. Now, that's not a very good profile. If they're basing it on something, my guess is on race quite often, but maybe not on race sometimes, maybe on other kinds of stereotypes, and they're wrong 98% of the time. I think that's a huge problem. And so the question becomes, do we stop this entirely? And some people would. They would say, unless you got grounds to arrest someone, unless you got probable cause, you may not stop anyone. Partly for the reasons that David and Reggie alluded to earlier, that it creates mistrust between especially minority communities and the government, and there may be some other reasons as well. Because even a non-African American might be affronted by this kind of thing. So we could stop them completely, or we could be much more serious about when the cops are wrong. They're wrong an awful lot, and apparently they don't seem to care because they're wrong 98% of the time. So maybe we should be much more serious about identifying when they're wrong and doing something to them when they are wrong. For instance, not just excluding evidence, because a lot of times they never prosecute these people. So exclusion is a non-issue for them, right? If a person is never taken to court, the cop never has to worry about exclusion. In the meantime, he's managed to harass somebody and maybe remove some drugs or guns from the street, or maybe just asserted his presence in the community. So exclusion might not be a good remedy. Maybe damages. Maybe we should actually make cops pay out of their pocket when it can be shown they did not have reasonable suspicion, or the reasonable suspicion was based in part on race. That might send a very strong message to cops. There are various other kinds of solutions we might be able to come up with, which I will save for later. But I wanted to pick up on what David was talking about in terms of the New York stops.
There's no fear of putting cops financially liable.
That would over-deter.
Yeah, I don't think the courts are going to be heading in that direction anytime soon. In fact, there are all these built-in legalisms,
immunities,
and qualified immunity, et cetera, that prevent that very thing. And I think it does decrease accountability. It's like, why do they have to be accountable for 98% of the time that they're wrong, when there is nothing, no consequence that is that they're being made to feel. As someone who has experienced and lived profiling, but has also advocated around the issue for over a decade at this point, I'm loath to say that I, at all in any form or fashion, support profiling. If I'm forced into a corner, I might say that a profile that is based on behavior is certainly more palatable to me than one that is based upon race and or stereotype. For example, in the context of the Christmas Day underwear bomber, or whatever they're calling him these days, without detailing every single fact, there were some facts that made him suspicious, right? There was intelligence about those suspicions and those facts. You didn't need to racially profile him. All you needed to do was share that information and that intelligence among agencies. President Obama said the failure there was not because, racial profiling wasn't available, but because you didn't share information, you didn't connect the dots. If behavior is legitimately suspicious, then I, for example, who have flown 5 to 10 times over the past 2 weeks, damn well want you to use that information to protect me when I'm flying. You know what I mean? No one wants you to dispense with common sense, but we want you to do things that work and that are effective, are legitimate, and that are legal. Racial profiling has been shown over and over again to not satisfy any of that criteria. And then again, as the Christmas bomber demonstrates, it's not necessary. It wouldn't have been necessary in that context. And in fact, I dare say it wouldn't have helped at all in that scenario.
All right, thank you, gentlemen. Along the lines of, I would believe, ethnic profiling, which would be more akin to what happened with the Christmas bomber. Do you think that post 9/11, like that type of profiling will be more permissible, or do you think it's just more pervasive? As in, you have the, I'm getting a little flustered here. My apologies.
Good.
Okay. So, at what point does it become profiling to a specific? I mean, David, you mentioned that it's specifics. If you have specific behavior and specific things that you're looking for, but how specific do you get until it becomes some kind of violation? Let's say if you look at someone that wears a hijab, or if someone that's Muslim or practices Islam or something to that effect, when do you get that specific before it violates the Constitution, Fourth Amendment, Fifth Amendment?
And not behavior, in my opinion, based upon the hypo.
Okay.
And again, appearance is, in my opinion, impermissible. It's an impermissible basis upon which to do some type of police intervention against somebody. With respect to your earlier question about post 9/11, well, the reality is that, yes, it's happening more. It's happening with respect to a certain category of people more so than other people. But let's not fool ourselves into believing that other categories of people are no longer profiled. I mean, there's profiling going on everywhere as we speak, in immigrant communities, against Latinos, against South Asians, certainly against Arabs and Muslims, et cetera, and against African Americans continually. It's still happening, but certainly post 9/11, the publicity, for lack of a better term, concentrated on Arabs and Muslims. And I think that there's no doubt that the increase was in part the result of a more concentrated effort to do so. But I would also submit that it happened more because it was either implicitly or explicitly consented to by the American people. I think that certain politicians played the fear card and ran rampant with the little bit of leeway that legitimately frightened Americans and citizens were experiencing, and sort of went crazy. Give them a little bit of flexibility to do what you think is going to be essential to protecting us all, and then end up creating something like the Total Information Society, where you're not satisfied with information about potential like airline hijackers, but you want information on all of us. And I think my point then is that we have been complicit to some degree in this expansion of profiling post 9/11, and I would also say in the area of immigrant profiling as well.
And I just want to add one point, and courts, I'm not going to speak to specific court cases, but courts, generally speaking, are very, very sensitive to the emotional temperature that's going on in the community. And I mean, when I was in law school, I was naive, and I thought that there are these principles and courts apply them, and that's not the way it works in the real world. Now, I'm not saying that the courts aren't ever doing the right thing. No, they do the right thing. But more often than not, in the work I do, courts are very much play into the fear, the fear card. And it's federal court. It's not just the elected state court judges. And so the climate on the bench is, generally speaking, not very receptive to the position that I would take and that Reggie would take about these issues.
Okay, Professor Slobogin, would you like to address?
Yeah, I guess picking up on a couple things that Reggie and David talked about, and also picking up on something I said earlier, it's rare that you're going to get a good profile. That is one that's right more often than not, or even right 1 out of 3 times. And one reason for that is the base rate behavior that we're going after, whether it's a terrorist trying to blow up an airplane or even possession of drugs, is extremely low. And when you have a low base rate for behavior, your profiles are never going to be real good because there's so few people engaging in the behavior you're trying to discover. So that's a real problem. We could try to make profiles better, but it's going to be very hard to make profiles real good. I mean, that 2% rate can be improved upon, but we're never going to get to 50%, or probably never even 30%, especially with respect to terrorists, because there are so few of them that we're rarely going to be able to be very good. So another possibility is to prevent profiling or figure out what kind of profiling we would allow or not allow. And we might be much more willing to allow certain kinds of preventive techniques, certain kinds of profiling techniques than others. For instance, when we're talking about a plane getting blown out of the sky, even though the chances of that are infinitesimally small, given the magnitude of the harm, we might be much more willing to put up with profiling than allow profiling in connection with getting someone for drug possession or drug sale, the kind of thing that happens every day on the streets. We might be less willing to put up with mistakes in that latter situation because the harm to society isn't all that great, and also because of what this panel is all about, because there's a much greater likelihood of racial profiling, I think, in connection with drug possession crimes than with anti-terrorism initiatives. However, there's also a possibility of racial profiling with respect to anti-terrorism initiatives. So what do we do about that? And here I think it's very important to emphasize what Reggie and David have both said, that race, as it turns out, because some people are going to not agree that using race is unconstitutional when you have knowledge that most terrorists are going to be either Muslim or Middle Eastern or a combination of both, and that many people who engage in drug trade are African American. Certainly not all, but many. They're just not going to buy that argument. I think it's wrong. I agree with David and Reggie that this should not be consideration, but that's going to be a hard argument to make. So what's the next argument for those people, those legislators, and maybe those courts, because they are politically sensitive? It doesn't work. Race is not an effective way of figuring out who's a terrorist or who's going to possess drugs, and I've got some data to back that up. Okay? Many people believe that if we're going to have an anti-terrorist profile, Middle Eastern descent, ethnicity, should be part of that profile, given our knowledge of what's going on in the past. But think about it. The underpants exploder was Nigerian. Okay? The single most dangerous terrorist that we've had on U.S. soil was Jose Padilla. Guess what? He's not Middle Eastern. Okay? He's Latino. In fact, the chances of a terrorist these days being not from the Middle East is very high. First of all, because they know what our profiling is like, and they can recruit people who are not Middle Eastern. So it's a mistake, and arguably a very bad mistake, to use that as one of our criteria. In fact, it might distract us from the criteria we should be using in airports and other places. The Israelis, who have to deal with this all the time, don't use ethnicity or race in deciding who to stop at airports. They use behaviors of the type Reggie was talking about. Because terrorists, for instance, are very highly stressed out. If they're about to get on the plane, I mean, not surprisingly, they're normal in that sense.
About to die. I mean,
yeah. Right. So there's a very high stress level. Okay? They also are trying to avoid detection in various ways. And the Israelis have become very good and nuanced at figuring out what kinds of behaviors, not stereotypes, not appearances, but behaviors correlate with terrorism. And that's what they use in their airports. And we've actually hired one of these Israeli folks to work in Boston's Logan Airport to help out with behavioral profiling there. Much more effective, in addition to much more constitutional than using race. Now, also in the streets, there's very interesting research on the extent to which race correlates with possession of drugs. It is a fact, as David was alluding to, that a disproportionate number of African Americans are stopped and asked to consent to searches of their person or their car for drugs. African Americans are singled out disproportionately, and then Latinos come in second and whites are last. Well, most cops think that's commonsensical, that that's the thing they should be doing. But in fact, the data show that race negatively correlates with drug possession. Okay? That actually it detracts from the accuracy of the stops. That they're less likely to find drugs in the car of an African American who's consented to that search than in the car of a white person. Now, why is that? It's not necessarily because whites use more drugs. That might be part of the reason. It's partly because they ask so many blacks for consent that they're automatically going to be wrong more often because the base rate, as I mentioned before, for drug possession is so low. So one possible solution, in addition to some of the others we've talked about, is tell cops this. Okay? They are, I mean, you know, they're not evil people necessarily, and they will respond to comments. You know, you are wrong most of the time when you're using race as a factor. You're actually going to be more wrong when you use race factor than when you don't use it. And conceivably, that would be one way of approaching this. There's actually a prosecutor in Michigan who has now told his cops, knowing this information, that unless you had reasonable suspicion to stop the guy in the first place, I'm not going to admit into evidence any contraband that you discover as a result of a consent search. Because I think it will probably be based on racial profiling.
Can I just add one point?
Oh, sure.
I know, Reggie, you would agree with me on this. What is very important is to educate the community about these issues, not just the police, but the community. Because if the community can understand that we're talking about tactics that are often going to be counterproductive and not effective, and you can really hammer that point home, then it's more likely that you can get some change to happen.
I think that's right. I think it does depend on like the messenger too. In fact, if you're actually going directly to the police officers themselves, they haven't been thrilled to see me generally speaking. They see ACLU and they're like, okay, we don't trust anything you have to say. But there is so much data to support your position about the negative correlation between criminality, drug use in particular. It hasn't resonated with
Well,
you know, Frank, that's not totally true. There was a point at which it was arriving at the point where it was resonating publicly. And so 2000, et cetera, we had reached a national consensus about racial profiling being wrong, ineffective, et cetera. And we're ready to do something about it to make it illegal on a federal level. But then 9/11 happened, and that sort of threw everything out the door. It really, really did. It's almost as if we had to start from scratch with everything that we had achieved. But yeah, no. But there's study after study after study that says African Americans possess, transport, et cetera, drugs much less frequently than their white counterparts. And it's been the basis of litigation that I have done. It's resonated to some degree with courts. But, you know, law enforcement agencies have responded to some degree with, you know, a battle of the experts or criticizing our methodology and our analysis and so on and so forth. But I think particularly in an economically depressing time, when you demonstrate that things aren't working effectively, and you have limited resources, and this stuff costs a lot of money, then that is the time when you're more likely to make some progress and sort of disseminate the message.
And you as potential litigants need to not just think about what do I bring in terms of the ability to litigate a case, but what are the other tools that I have to change the conversation. That is really fundamentally important. It's not something I learned in law school, but when you're out there practicing and hitting your head against the wall in the courts, you've got to figure out other tactics and be flexible, and that includes a media strategy and a public education strategy.
Excellent answers, gentlemen. I do have one comment before we open it up to the audience. Now, profiling, as you mentioned, it is a very serious issue, and it's taking place on a national level. But to what extent do the individual states regulate or mandate what can and cannot be done as far as what can be done in a profile versus the individual law enforcement agency in a county, in a particular county, versus what is acceptable nationally? Is there federal laws that say you cannot do a certain thing in a profile? Not necessarily a search, but just a stop and frisk, as we mentioned earlier with Terry versus v. Ohio.
I think it varies from state to state. Okay. There is not a federal law that prohibits racial profiling. IRPA, the Interracial Profiling Act, was introduced initially in, say, 1997 and never went anywhere. It's poised again to be reintroduced. Certainly it was before Christmas and before Massachusetts. Anyway,
all bets are off on anything.
I digress. I digress. But notwithstanding the lack of a federal law to prohibit racial profiling, obviously there's the Constitution and the 14th Amendment and the 4th Amendment and so on and so forth. Title VI that would be implicated in a lawsuit. But states, I think to date there are 13 states that have anti-profiling legislation on the books. And then beyond that, there are hundreds and thousands of police departments that themselves have said we are not going to profile. They voluntarily assumed policies that prohibit profiling. And then thousands that collect data, hundreds of thousands that collect data, and so on and so forth. But it varies from state to state and then from municipality to municipality. I'm not sure if that answers your question or not.
Yeah, it did. Does anyone else want to add to that? Professor Slobogin?
Well, I guess one thing I'll add is that what Reggie was just talking about has been extremely useful, because even though we don't have nationwide legislation and there is variation from state to state, because of the legislation that does exist, we've accumulated a lot of the information I was referring to earlier. So we know racial profiling goes on. We have objective data to that effect, and we also know it's not effective. And so we have information we can give policymakers and chiefs of police and so on. And it's really important to do this. I agree with David that the messenger has to be the right person. You have to have someone who's credible with the police. But assuming you can get the right messenger in front of the police and give the police this information, I happen to believe, this may be naive of me, I happen to believe the police will respond in an appropriate manner. Because as Reggie said, they got limited resources. And if they can be shown that something's not effective, I think they will stop doing it, or at least curtail their illegitimate behavior. But they have to be convinced that it's ineffective. One example of how hard it is to convince them of that is there's a famous case out of Maryland where there was clear evidence of racial profiling. Yes, your case. Do you want to tell them about it? You know more about it than I do.
No, I forgot.
It's a great case.
I want you to tell them.
Well,
I'll
just very briefly tell you.
Yeah, absolutely. And I'll chime in if I remember.
Yeah, and I might even get it wrong. That's why I'm gulping here. Maybe I.
Oh, because it's wrong
but,
in the flattering light. I'm not.
Well, anyway, the court issued an injunction telling the police you may not use race as a criterion for stopping people. So that was the injunction the police were operating under, and they knew that there was a record going to be kept of who they stopped and what their racial and other characteristics were. Despite that fact and this, you can correct me if I'm wrong about this, of the 732 citizens detained and searched by the Maryland State Police after this injunction was issued for traffic violations from January 95 through June 96, 75% were still African American. and 5% were Hispanic. These are cops who were told not to do this and knew that what they did was going to be recorded, and they still did this.
Not only that,
okay.
they were required to keep the data.
Yeah, they themselves were required to keep
turn
the
that data
data
over to us.
So they obviously, and let me finish with the statistics. Of the 12 officers involved in such stops, 6 stopped over 80% African Americans, 1 stopped over 95% African Americans, and 2 stopped only African Americans. And this is under the circumstances. Yes. Now, what's going on here? They think, I don't think they're totally evil, or I think they are racist, but I don't think they're totally evil. I think they are convinced this is an effective way of stopping the drug trade. I think the only way we're going to get through to these people, other than maybe a damages regime which actually makes them pay money, say, look, this is not working, okay? It is true that you do get some people. You're going to luck out sometimes. But overall, you're going to be wrong way more often than you're right. And you're wasting resources when you do this kind of thing. Now, the other option, of course, is to fire these guys. But my guess is they'll be replaced by people who are similar. So education is important. I happen to think some kind of regime that's more than the exclusionary rule, which would make the cop pay if he's acting in bad faith. And if he's not acting in bad faith, and we can't prove that, and you all know as litigators it's hard to prove that, make the department pay regardless if there's not reasonable suspicion. Somewhere there's going to be some change.
The police departments have been made to pay, but it doesn't get to the level of the individual line.
I think the police should have to pay if it's bad faith, and I don't think there should be any immunity. And in fact, even the court's current decisions only allow qualified immunity, which means if they act in bad faith, they are personally liable. Though the department may indemnify them, I'm totally against a ban on indemnification. I mean, I'm for a ban on indemnification.
All righty, thank you, gentlemen. At this time, we will take questions from the audience. Carly.
I just had a question, and for anyone to answer, about the standards, having not taken Professor Slobodan's criminal procedure class, the standards including the racial profiling cases that you take at the ACLU.
No, you go ahead and answer it, because you know more what's like on the ground.
I'm just going to say, generally speaking, it's extraordinarily difficult. I mean, the claims generally are equal protection, which requires proven intentional discrimination, which the courts have made almost impossible to do. But sometimes you can do it. Sometimes you can sometimes there's a smoking gun. There's a couple of very brazen police chiefs have admitted to using racial profiling. In fact, the police chief in Homer, Louisiana, said he wants African-American men to feel afraid of being arrested whenever they come to Homer, Louisiana. So people are really sort of bold about that. And when you have people saying stuff like that, you seize upon it and you definitely use it. And we also bring Fourth Amendment claims, which, the Fourth Amendment isn't particularly strong either anymore. Pretty much has been eviscerated by the courts. But, sometimes you bring these cases because you really have to, based upon principle. And you hope things will shake out accordingly. The data that the professor has alluded to have been our friend. I mean, sometimes courts will receive that data well, other times not, but certainly, generally speaking, at least to a certain point in the litigation, it can take you pretty far. But that really underscores the point that David was making. So you should continue to bring your cases. You may win, you may not. Frequently you lose, but that's not the point, because you're also educating the public in the meantime. You were forced, because of the hostility of many courts, to use methods and mechanisms that you wouldn't otherwise necessarily think when you're in law school that you would have to. You think, like David said, this is the law, these are the principles, my facts demonstrate and support that, so I should win. But no, I mean, judges are people too. And they certainly are impacted by the political winds of the time, who may have appointed them, whether they are up for election again, whether they want to move from the federal district court to the Court of Appeals. I mean, and those things I submit impact their decision-making as well. But I have been forced, given my general area of advocating against discrimination, to go on TV, to help lobbyists, to talk to newspapers all the time. It's a holistic approach to advocacy and part, again, because courts have not been as receptive to what I think they should be as they could have been.
Every once in a while, though, you get a smoking gun. I mean, we have this case now where we're litigating. Our clients are one, a retired, decorated police officer, and his brother, who is a music professor at a college in the Northeast, and they're driving through Ohio in this U-Haul truck moving their dead mother's belongings from the West Coast to the East Coast, and they're stopped supposedly because I think the tires crossed one of the lanes or something, and the officer initially says, "Well, I wanted to make sure you weren't falling asleep," but then they wind up getting the drug dogs eventually. They don't find anything on them, but it's really hard going in these cases. The court was like, this doesn't sound like you've got any kind of a claim here, until the officer had the audacity to say, I didn't think, in the deposition, I didn't think that the driver was, I thought he was white man, and the guy is my complexion. I mean, that is obviously a lie. And we started to get more traction with the court when we were talking about settlement at that point, to the point where the court was like, state, you can claim, you can say you want to file a motion for summary judgment, but I don't really think I'm going to give you permission to do it, because, and he eventually backed down on that, and I'm glad he did, because he ought to at least give him a chance. But we're not going to now I don't think, have to worry about being tossed out on summary judgment ground, because every once in a while you do get lucky, even in these tough cases.
You have to bring them just because of the principle of it.
Yeah, but equal protection law requires intentional discrimination. Unless you get a smoking gun like that, it's very, very hard to prove the case, which is why I think the law needs to be changed along the lines of what I talked about in Michigan. That once a person's stopped, what cops typically do, at least if it's a car stop, or even if it's a street stop, then they ask for consent. Because they know they can't just force their way into the car. If that's proven, then they got real problems. And they usually expect to get consent. Why? Because the person's sitting there saying, well, what happens if I don't consent? I'll be here a lot longer, and maybe something worse will happen. So they get the consent, and then the car is searched. Sometimes something's found. A lot of times, nothing's found. What's happened in Michigan, though, is, as I said before, the prosecutor said, I'm not going to admit into evidence any evidence found as a result of one of these consent searches unless it can be shown there is reasonable suspicion to believe there was contraband in the car. Well, what does that do to the cop? He has to come up with articulable reasons as to why he asked for consent. And if all I can say is, well, the guy was black, he's lost. Okay? If all I can say is, nothing about race, but the guy was nervous, he's lost. He has to come up with some articulable reasons in Michigan before there will be any ability to introduce that evidence. So the import of that law, which unfortunately only exists in Michigan and one or two other, New Jersey also has adopted this idea, it does put a constraint on police, because after all, one reason they do this is to get the contraband. If they can't introduce the contraband, it's not going to do any good. I happen to also believe there should be damages actions in addition, but if we're not going to have those for all the reasons that Reggie mentions, at least change the Fourth Amendment law so that exclusion will be have more bite in these situations.
Are there any other questions from the audience? Danica?
We all know about the school bombing shootings and like the Oklahoma City bombing shootings and all this kind of thing. Well, not shootings, bombing, but Oklahoma City bombing and school bombing. Do they profile those people who commit those acts? Because if you look at it like historically, a lot of times those are typically like maybe like white male teenagers between some age group that they may have and social awkward issues, things like that. Do they profile them, or what happens to that data?
Well, I mean, I have not studied that issue very carefully, but I do know. My first initial reaction was, well, did they profile white men with buzz cuts after the Oklahoma City bombing? Well, no, they didn't. But we've all heard stories about the loner kids who look goth and wear trench coats, getting a hard time now. And if they're writing, drawing cartoons of involving, yeah, you're getting nailed. So I do think that's happening at some level.
The federal government loves profiling. They pay millions of dollars every year to have people profile all sorts of different kinds of acts. And that was pre-9/11, but now post-9/11, TIA alone costs millions and millions and millions of dollars. Like I said, it was defunded in 2003, partly because some of you who heard my lecture on Friday know this, because Admiral Poindexter, who was not real smart when it came to PR, he developed an icon which showed an all-seeing eye looking out over the globe, and the maxim, knowledge is power. You can't imagine a more scary symbol. And even the Republicans, I mean, by a voice vote, they defunded TIA. The entire Senate voted against this because of that icon and what went along with it. But it hasn't stopped TIA-like programs from occurring, and it's based entirely on profiling. Now, mostly terrorist profiles, but not entirely. Also, other kinds of profiles that have to do with what they now call narco-terrorism. It's not really terrorism. It's just narcotic, syndicated crime, but they use the word terrorism hyphenated, so it's more likely Congress will fund it if they somehow attach it to terrorism post-2001. It's all based on profiling. I have a couple of friends who make their living off of profiling.
All right, thank you. Are there any questions in the back?
The hospital, day of birth, sorry.
You probably have more experience, sort of with, with the big picture on that. I'm not totally surprised at all that that happens. I mean, I think every one of us in this room is affected by race and has race somehow impacting our thinking. And black folks don't get a pass on that. And so I'm not surprised at all that that's the case. I don't know what
It's police culture. Whoever is a part of that culture is certainly as likely as anyone else to engage in profiling.
I think it's important to recognize an aspect of profiling. It's common sense, quote unquote. This is passed on from generation to generation of cops. But since race is part of the profile, there's what Bernard Harcourt has called the ratcheting effect. In other words, since African Americanness, so to speak, is part of the profile, they tend to stop African Americans. Well, lo and behold, a certain percentage of them do happen to have drugs, and that confirms what the profile already says, and so it's a self-fulfilling prophecy, and so black cops as well as white cops say, oh, well, this is right. I mean, African Americans do tend to have drugs or weapons more often than whites, but that's not true as a statistical matter. It's just that the profiles are self-fulfilling prophecies. You're only stopping blacks, so the only people who are going to have drugs or weapons are blacks. It's a real problem.
Referred to as a perverse illogical profiling. And to be clear, African American cops stopping other people, we aren't talking about African American cops stopping white people. We're talking about African American cops stopping other African Americans. So just to be clear, African Americanness is the thing that animates a lot of the behavior that we're complaining about tonight. Not everybody, although I listed a number of categories of people who are subjected to racial profiling, we obviously know that not everybody is. Those who are a minority and tend to be disfavored in society are the ones who suffer.
All right. We had a hand up over here.
Sorry, just going on.
We're going to have one second. We're going to have another round where we take from the audience, but we're going to get back to the program. Go ahead.
Off of that, the statistics, Professor Slobogin, you were giving earlier about the cops who were told not to arrest a black person. Is there any information about how many times they were right? Even if they were 90%, were they right 85% of the time? Or, because I know you gave us the national statistic, but in that actual area, do they tend to be right?
Which study are you talking about? Because remember, I talked about the New York study, 175,000 stops, 2% ended up being arrested. Not that one. The Maryland one, Reggie's case, Let me see if I have that. There is some national data on all of this. I'm not sure I know exactly what happened in Maryland.
But your question again is...
Reggie, you would know this, right?
I need to understand the question. How many times, I mean...
If some cops arrested only blacks or blacks 80% of the time.
Yeah, I can give you that. I have that here. So data showed that 1/3 of all stop drivers had some drugs in the car, and that while drug-free Hispanic and African-American drivers were far more likely to be stopped and searched than drug-free white drivers, a larger minority of the searches of the first two groups, African-Americans, by a small margin, uncovered substantial quantities of drugs. So African-American Latino drivers were slightly more likely than whites to have drugs, but remember, they were stopped far more frequently than whites. So you work all that out statistically, and what you're left with was probably whites are more likely to have drugs in their car than African-Americans and Latinos.
All right, does that answer your question? All right, we're going to go back to the program, and we're going to switch gears a little bit and get into police abuses, police conduct. Post 9/11, there's been an increase in incidences of alleged police abuses, primarily with regard to minorities, ranging from California to New York. Are the courts becoming more tolerant of aggressive police tactics, or have the laws actually been changed permitting this increased level of aggression? What do you think is the explanation for that trend?
Are they being more lenient towards use of profiling and stop and frisk campaigns and
Specifically
checkpoints and that kind of thing?
Abuse where you're getting aggressive with the person that you're taking down, shooting before saying stop, not calling out police officer, those things around that line.
Well, a lot of it depends on, when you're talking about police who shoot or somehow physically injure folks, let's not forget that the prosecutor has a very important role to play here. And in Cincinnati, there have been issues where police officers have not been indicted for, engaging in misconduct that I think a lot of reasonable people would say should have resulted in an indictment, and a lot of that's political. So I think that the prosecutor certainly has a role to play in that. It's not just the courts being tolerant or not so tolerant. I'm not sure what thoughts are.
I think that's right. I think it depends on the court. I think it depends on the jurisdiction. I think it depends on the facts, the prosecutor, whether the community is engaged and will push back. So I think it depends on a lot of variables.
Yeah, and as a general matter, though, from what I've observed, I haven't looked at the data about this, but from what I've observed in the last several years, I've seen way more increases of, let's say, a black police officer is actually killed while off duty in plain clothes by fellow officers, or the incidents with Sean Bell in New York City when he was killed trying to leave his engagement party or his bachelor party.
I'm not sure that certainly is, what I can say is it's certainly not decreasing. I'm not sure if it's increasing so substantially or if we're more attuned to it. It's publicized more. Communities are empowered, so they speak out more. Everybody has a video camera on them and can expose these things more. I certainly think it happens a lot. But I feel like it's always happened, though, frankly.
Yeah, I guess I'm not sure about the premise of the question. We don't really have good data on whether there's been an increase in deadly force. You got to remember that back in the mid-'80s, the Supreme Court actually held in Tennessee versus Garner that the police may not use deadly force unless the individual they're using deadly force against is armed or somehow threatens the officer. And that changed the law, which up until that time allowed the police to use deadly force even when the individual they're using it against was not armed and dangerous. So at least as a matter of law, it should be less likely deadly force is used, if only because now the Constitution bars the use of deadly force in some circumstances where it was allowed previously. Now, I don't know if actually police are paying any attention to Tennessee versus Garner, but at least theoretically, there should be less deadly force. I will add, though, that in places like L.A., there certainly has not been a decrease in the number of lawsuits which allege excessive force, not necessarily deadly force, but excessive force by police officers. And L.A. is paying through the nose with respect to these kinds of cases. It has been and still is paying through the nose. So I guess I sort of agree with Reggie. I'm not sure there's been a huge upswing, but I don't think there's been a decrease either.
Well,
It's pretty constant.
okay. Accepting that it's constant, I mean, how do you recommend or how do you feel as though this can be changed? I know you say excessive force, but is there a way for the legislator or anyone to stop shooting and then asking questions afterwards? I mean, what
Well,
efforts?
I have one suggestion. This is a broken record, but make the cop pay personally. I just got through saying LA pays through the nose. Who's paying that? The department. Cops get indemnified. They don't have to pay a single penny out of their pocket. They are paid, their counsel's paid for. If they lose, which they sometimes do, obviously in LA, the department pays the damages. I think if the cop is shown to use excessive force and in any way, shape, or form is in bad faith, they ought to have to pay, and of course the department also to take appropriate action. That would send a much stronger message. Why aren't they treated that way? Why is there indemnification? Because the police departments think, and those of you who have taken my criminal procedure class have heard this terminology before, think that you have to have a certain number of meat-eater cops on the force, as opposed to grass-eater cops, okay? Cops that will go out there and do the dirty work that we all think needs to be done. The meat-eaters are the ones that get sued. They're the ones that use excessive force. The department indemnifies them and doesn't necessarily kick them off. Remember Mark Furman, the O.J. Simpson trial? He was horrible. He was sued or associated with the suit 44 times, and he was still on the LAPD force. Why? The department thought they needed him. They needed him out there in the front lines to make sure the dirty work was done. We're not going to get rid of those people unless and until they are personally liable, as well as the department having to pay through the nose if there's a good faith action of excessive force. So that's one thing to do, not necessarily the only.
One more round into the audience. Okay. Question.
Has anybody looked at how police are rewarded rather than a punitive solution like you propose? Because it strikes me that, if you reward prosecutors for convictions, you're going to end up with bad convictions. And if you reward cops, for the number of people they stop as opposed to what's effective, you're going to get lots of stops and maybe profiling. I mean, how are police rewarded, for their performance, and what impact might that have to encourage them to apply more effective methods?
Well, certainly some of them win Officer of the Month, Officer of the Year, and it's all driven by how many people they stop and quotas, and so they can fabricate evidence. I mean, it really is precisely as you have stated. There's a built-in incentive for doing the things that we're complaining about tonight, because they get the adulation and admiration of their peers, and they stopped the most people, they've gotten the most, they've found the most drugs or whatever, but they get, and I don't know if there's a monetary component to the if they get paid for it as well, but they certainly are incentivized to do these things because it's part again of the police culture. For the bigger and better you are, the more you're going to be appreciated and respected. And your question is well taken.
Yeah, I love the question because what it demonstrates is just how critical it is to bring a problem-solving approach to these very complex issues. And I would encourage all of you, when you become practitioners, to really bring that out-of-the-box problem-solving approach, because that's what can make these issues a little bit better. I mean, it's not going to solve it, but it can move it along in the right direction.
I mean, I've seen many Officer of the Month and Officer of the Year documents when I've gotten discovery. I mean, they really are given benefits, but essentially.
Collars, scalps, however you want to put it.
Collars is the word they use.
Yeah.
The number of collars gets you Officer of the Month.
Yeah.
And it doesn't really matter how the collars happen. Now, if you beat the guy to death, that might get you in trouble. But anything short of that, if it's a collar, then that's good.
It helps your badass reputation, too, I mean.
Now, Albert Quick has written an interesting article where he suggests one way of counteracting that is rewarding cops for good collars as opposed to bad collars. It might be very hard to institute that kind of regime, but he actually has a number of practical suggestions. David mentioned thinking out of the box. This is one thing, using basic reward and punishment principles. You reward cops for good collars, meaning collars that adhere to the Fourth Amendment, that don't involve excessive force, that don't involve racial profiling, and so on.
And then another sort of benefit is that you get promoted and then get invited to go teach other people how to do what you've done.
Thank you, gentlemen. All right, one more question.
Sorry, one more question. I guess for the past 3-4 years, local law enforcement in many communities have been empowered by the federal government to enforce our national immigration laws through the 287G program, which allows and asks officers on the street not only to identify who is an immigrant, but who came across the border without the proper papers. And I'm wondering what your experience has been in how the 287G program has changed the mindset of officers in carrying out that policy, and also what impact it's had on the community in terms of tolerance for or intolerance of that kind of profiling.
Let me just speak briefly to it. It is in Ohio, and particularly in a county that's adjacent to the county where I live in, it has been a license for harassing on a nonstop basis immigrants in our community. And just recently, to compound it, the state DMV said that if you can't prove that you are here legally, you can't even register your car, and there are all sorts of policy issues with that. And so now you combine these very aggressive police tactics to ferret out folks who might be here illegally, and then folks not even now able to drive, and it is just awful. And so the mindset, what it's done is it's really there's a very he likes to consider himself law and order sheriff in Butler County. What's that? Like it. Well, you're thinking of the one in Phoenix?
Arizona.
Oh, yeah.
Well,
he likes to think of himself as the Joe Arpaio of Ohio, focused on ridding, as he would put it, I would not put it that way, ridding the community of immigrants. So I think it's very problematic, and it's an area where we're now starting to focus a lot more of our resources into trying to counteract in some way. And I think the public is, for the most part, because it's not getting all of the information, it's getting a very biased account of it, is very supportive of what local law enforcement is doing. And I cannot emphasize enough how it is important to change the conversation. Litigation only gets you so far. We've got to be hitting in the media and finding the right people, as Reggie was saying earlier, to speak out and to build coalitions to address this issue.
The only thing I would add to that is that I totally agree. It's absolutely pervasive. It's all, not just in Ohio, not just in Arizona. It's really all around the country, and police departments get paid to do this. So there's a monetary incentive for taking on these 287G programs. And the impact on the public is that the public supports it. And the one thing that I wanted to tweak a little bit about what David said is that it isn't just immigrants, right? It's American citizens, too, who happen to be of Hispanic or Latino descent, who are now regarded with suspicion, even though their citizenship is no less than mine or yours. But they're now suspicious because of their sort of national origin, if you will.
One twist I want to add to this is that one possible litigation strategy is to make a federalism argument against what's going on. Because even though it is pervasive nationally, there are some locales that hate 287G. Because even though the federal government does provide some money, it's halfway to being an unfunded mandate. Because a lot of these police departments have to devote a whole lot of resources to this program that they don't get totally reimbursed for. So in sort of an ironic way, litigators like David and Reggie could argue there's a constitutional problem here along the lines of being an unfunded mandate that conceivably could put a stop to a program that you really want to put a stop to for other reasons, the racial profiling.
And with the conservative courts, that would have some traction.
Exactly
so
right.
That's an argument that's very attractive.
Right. Because again, the financial, economic sort of status of many states is to be in poor condition. States are suffering financially, in other words. And ironically, in Texas, for example, conservative legislators are the ones who help pass, for example, laws that would reduce the number of prisons being built and so on, and people sent to prison, et cetera, because it costs a lot of money. So you really can get traction when you bring in the financial component in these really struggling communities.
And in Ohio, we got a similar dynamic going on right now, just to make a quick point, and it's the Democrats who are fighting it because they don't want to be painted as soft on crime. Yeah. So these issues cut across political lines, although you may think they don't, they do.
One last question. Well, not one last question, actually. I came across an interesting statistic about the Florida prison system, actually. It said that 60% of the people that populate the Florida prison system are African American, while only 10% of them take up the actual population of Florida. Do you have any theories as to the sentencing issues, as to why there are so many African Americans in jail versus the amount that actually commit the crimes? This may be out of the scope. We've taken a look at similar statistics in Ohio. What we're finding is that the discrepancies are not happening, for the most part, at sentencing. The judges, and we were a little bit surprised by this. We thought that we were going to find that judges were treating white and black defendants differently, and that didn't really bear it out. But what it does indicate, we think, and I think this would bear out in Florida as well, is that at the front end, in terms of like who's getting targeted by the police, what the charging decisions are by the prosecutor, that's where you see a lot of the discrepancy. So from the prosecutor is where it really starts.
Police before, and then the prosecutors also contribute to that. And there's been a lot of good work that the Vera Institute of Justice is doing in New York. Wayne McKenzie is a prosecutor there who's trying to work with prosecutor offices around the country for those offices to actually measure whether they are charging in a racially discriminatory way. And his argument to the prosecutors is that, look, this can be a tool for you, to the extent you care about politics. I mean, if you bring in, we do this study, and whether we find issues or not, you can at least be proactive and address it. And that can buy you a lot of support in communities that don't trust you. So I'm hoping that more of that's going to be happening, because as I think one of the themes that we've been hitting hard tonight is that evidence really does matter, and folks need to be looking at their charging decisions and seeing whether there's bias there, and if there's evidence of it, change it.
I would only add to David's statement that even in schools, when you talk about the school-to-prison pipeline, where kids of color are being disproportionately sent to the principal's office, suspended, sent to alternative school, introduced into the juvenile and criminal justice system, those disparities, at the very front of the system end up with disparities on the very end of the system, with people of color disproportionately represented in prisons. So it starts very young, unfortunately, very early on. And many people sort of conspire, if you will, to get that end result.
One thing I would say in response, particularly to the Florida data, is that, of course, one reason we have these kinds of panels and we're worried about racial profiling is that discretion is available in many different parts of the system. In Florida, interestingly enough, they have what's called determinate sentencing, which means that the sentence range that is available to the judge is pretty narrow. The judge, in other words, has very little discretion. What does that mean? All discretion gets squeezed to the prosecutor and the police, and so that's where you see the discrimination. In jurisdictions that have indeterminate sentencing, I wouldn't be at all surprised if you saw a lot more abuse of discretion at sentencing, as well as with prosecutors and police. So the the lesson that might be learned from this is that limiting discretion can limit the impact of race on decision-making. Florida might be proof of that.
And we'll take some questions from the audience before we close. Yes.
I have one question about, I apologize, I'm terrible with names, the little panelist.
Reggie.
You mentioned earlier that, you said if you were forced to say what kind of profiling you would find acceptable, you said behavioral.
Sorta, I mean.
Yeah, that's quote unquote. Definitely not appearance-based. But isn't it the case where maybe appearance-based profiling in certain circumstances would count as reasonable data? I'm thinking like neighborhoods with high rates of gang violence and certain, whether it be symbols tattooed or colors of clothing or hand gestures or hand signals correlate with certain gangs. And, if that's technically an appearance, I would think. So,
Well, I was equating appearance with race or ethnicity, essentially. And so I will never, ever support that. And my problem with what you described is still, it casts the net too broadly. And it's going to bring in people who may like the bright colors of a gang that they're wearing, who might think they're trying to be cool because they want a tattoo. It could be a fake tattoo. Who knows? Maybe they're doing it to protect themselves. And I mean, to the extent that the net is cast so broadly that it really doesn't improve your hit rate or the rate at which someone is guilty of something that you think they are, then I wouldn't support it. I think that you run the risk of bringing in too many innocent people simply because you're based on, again, and so I turn again to behavior. And just because of how you look or dress, I think is not sufficient indicia of criminality.
And if you think about, oh, I'm sorry, I didn't mean to.
I'm done.
And if you think about the baggy pants phenomenon, I mean, there's so many people who wear baggy pants. I mean, it's certainly not all of them are.
It's conceivable that gang regalia in combination with certain behaviors would give you enough suspicion to stop an individual and question them. But if the suggestion is having gang regalia means the police can do something to the individual, you're basically allowing the police to harass anyone with gang regalia on their person. And again, there's some innocent reasons for having that. There may be some not so innocent reasons. In fact, they actually are gang members. But does that mean that you can stop and harass them just based on that fact? The Supreme Court of the United States in Chicago versus Morales has said no. Back in whenever it was, I can't remember exactly when the case was decided, there was a Chicago ordinance which held that it was permissible to arrest a person who the police had probable cause to believe was a gang member and who failed to disperse when the police asked them to disperse. And the Supreme Court of the United States held that that was an unconstitutional ordinance for the kinds of reasons that Reggie and David are talking about. Now, I might disagree with that opinion, but if this Supreme Court is willing to say that, then you've got a problem.
Right, because you can be a gang member and simply want to take your child to school. Should somebody stop you because you really...
And of course, the reason for Morales is the potential of abuses of discretion that can occur.
Any more? Tracy?
And race is one of the factors.
I think the courts find less of a problem with that. And we don't necessarily, the description is very specific and reliable and limited as to geography and other limiting factors, and we're not necessarily considering that to be racial profiling. And I think courts agree that, the problem, though, is that you can abuse that. You can, like in the town of Oneonta, New York, stop literally every black person in the town because of a suspect description. So it's not without limit, but generally speaking, it's less offensive, I think, to courts and maybe even advocates against racial profiling.
Well, can I throw out a counter hypothetical, so to speak? Let's say that there is a purse snatching that happens. The description of the purse snatcher, the only description that's given is black male wearing dark clothing and a black hoodie, okay? A hooded sweatshirt. The police stop a 6'7" black man 11 minutes after this in the same neighborhood who's not wearing a hoodie. Do you think that that's appropriate? What do you think a court would do with that? Say that the police were right to stop this guy? Black male, black hoodie, and this is an area where there are lots of black folks around.
Same height, just the absence of the hoodie is what you're saying.
Yeah, and no height description.
Oh, no height.
No height description.
I'm sorry. Okay.
He happens to be 6'7". There's no mention of somebody that's unusually tall. Well, this is a case that we had at our office. We have a law school clinic that runs out of our office, and it was one of our student cases. And that doggone court found that the police were well within its rights to stop our client and would not suppress the evidence. And he was not the purse snatcher, by the way. What happened was he, in the back of the police car, they asked him what his Social Security number was, and he was one number off. And they charged him with falsification, and we were trying to suppress the statements based on that. And at that oral argument, the several judges were like, what are the police officers to do? What are they to do? And we had lots of answers to that, but they didn't care. They didn't listen. My point is that this stuff is like, it's hard. It's charged. Racially, it's charged. It's charged in terms of the politics of wanting to be tough on crime and supporting the police. And that's an absurd result. That's an absurd result. There's so many things the officer could have done. If he, first of all, he didn't fit the limited description of the clothing, but you know what? Why not radio back and ask for some sort of information about the height? Because that's unusual. 6'7" is tall. Trust me, I'm short. I stood next to him. That's tall. So that was a real kick in the stomach when we got that decision, and the Ohio Supreme Court wouldn't take it up, and it's just.
All right, thank you, David. We're going to have one last question posed to the panelists, and then we're going to call this. Let's see, the first question, or the last question, will be, at what point does prosecutorial discretion rise to the level of federal intervention, and realistically, what can the federal government do to stop an abuse such as what occurred in the Gina 6 situation? And without going back over the facts of Gina 6, what level of prosecutorial discretion do we allow before the federal government just says this is just blatant racism? And
when should the federal government be able to intervene in a state prosecution based on a racial discrimination claim?
like a direct violation of the Constitution. I know it's very.
That's a very weighted question because there's so many different issues involved there in addition to racial discrimination.
Or to make it less complicated, state. Instead of the federal government, the state legislator coming in saying this is just wrong on all levels.
I mean, I'm always persuaded if the situation is so heinous that you can't look away from it, and therefore it might necessitate federal or higher state intervention, or if there's a pattern. If there's a pattern of this prosecutor acting wrongly, discriminatorily, abusing her or his discretion repeatedly, then it might warrant the intervention of the federal government, the DOJ, or a state legislative body.
Okay. Does anyone?
Maybe disbarment of the prosecutor after the fact, if not before. And that's what happened with the Duke lacrosse case, which is maybe, obviously it's the reverse kind of situation we've been talking about all evening, but that's what happened there.
All right. And, all right, well, thank you, gentlemen. Thank you for attending the panel discussion. A round of applause for our panelists, please.